So as we all know, Destiny is in an ocean of hot water right now over allegedly sending explicit videos of Pxie to another woman without Pxie's consent. He's currently facing civil and potentially even criminal charges for doing this, and after having made a few videos on this case, my opinion so far is that Destiny is honestly cooked. However, some commenters have asked a question about the federal law he's accused to have violated and pointed to a potential loophole that could render the entire law inapplicable. But does this loophole really exist? Well, that's what today's video is all about. What's up, everybody? Welcome back to the channel. My name's Scotty-O, aka the Gen Z Attorney, and I currently work as an assistant district attorney in North Carolina, meaning I'm a litigator. I'm in courtrooms all day, every day. On this channel, I make videos about real-life civil and criminal cases, pull the curtain back, and explain how the justice system really works. And I'd like to say at this point that I've become the preeminent Destiny versus Pxie historian, because so far I've made videos covering Pxie's complaint, Destiny's response to the complaint, and summarizing all of it into an easily digestible video. But since I've come across this information pointing to the federal law and the possibility that that entire charge gets thrown out, I want to make this video to really clear the air and explain what I found through my research. So without further ado, let's jump right in. So the law in question today is 15 U.S. Code section 6851, and it's the law that Pxie cited for count 1 of her complaint because the law does create a civil cause of action for the disclosure of intimate images. But to understand how this law applies, we first have to understand where it comes from. And this law originally comes from the Violence Against Women Act, which was first introduced into the Congress by none other than Senator Joe Biden, who initially sponsored the bill in 1990 and advocated for its passage all the way up through 1994 when Bill Clinton eventually signed it into law. And upon being signed into law, it did a couple things. Among those things, it created new criminal provisions governing domestic violence, it provided for more resources for the victims of domestic violence, and it allowed for things like domestic violence restraining orders to be applicable across state lines. So pretty common sense stuff, and since its passage in 1994, it's been reauthorized several times, including in 2000, 2005, 2013, and most recently in 2022. Notable, of course, that it happened to be President Joe Biden that signed the reauthorization in 2022 of the bill that he sponsored all the way back in 1990. So yes, it's been reauthorized every so often to reflect the changing times, and in this most recent reauthorization, it set out the language of 15 U.S.C. 6851, which creates a civil cause of action for victims to sue people who disclose intimate and explicit images and videos of that person without their consent. And as you can see from reading the law, it states that an individual whose intimate visual depiction is disclosed in or affecting interstate or foreign commerce, or using any means or facility of interstate or foreign commerce, without the consent of the individual, or such disclosure was made by a person who knows that, or recklessly disregards whether the individual has not consented to such disclosure, may bring a civil action against that person in an appropriate district court of the United States for relief as set forth in paragraph 3. So if we decipher that legalese into some understandable elements, there's basically 4 elements here. First, that there has to be an intimate visual depiction of an individual. Second, that depiction has to be disclosed to a third party. Third, it has to be done without the consent of the individual depicted. And fourth, the disclosure has to know or recklessly disregard the fact the individual did not consent to the disclosure. So in a nutshell, it's just saying you have to disclose someone's nudes without their consent. Now, when someone violates this law, the law lays out the damages that a victim is entitled to, and it lays them out in 2 categories. Going back to the law, it says that in a civil action filed under this section, an individual may recover the actual damages sustained by the individual or liquidated damages in the amount of $150,000, plus cost of action, reasonable attorney's fees, etc., etc. But what that's saying there, it's creating an either-or, where the damages that a victim is entitled to is going to be the greater between those 2 numbers. And since it's statutorily enumerating $150K as the liquidated damages, that here is serving as the baseline, meaning that anyone who's the victim of this is entitled to at least $150K damages, if not more, if they can prove their actual damages are greater than $150K. So that's the history and that's the law itself. Now it's time to apply the law to the facts, so we can understand what potential loophole there might be. And to understand this, we have to understand that timing is going to be key here. Because as I've made clear in all my videos, I believe it's evident that Destiny has in fact violated this federal law according to the way the law is written. In other words, I think it's all but been proven at this point that Destiny did disclose videos of Pxie to someone else without Pxie's consent. And I know that because in covering his response to the allegations, instead of actually addressing the merit of whether or not he did make this disclosure without Pxie's consent, he instead spends the overwhelming majority of his response video going after Pxie and trying to discredit her as a way of mitigating her claims of damages. Right, by essentially trying to paint her as a quasi-extortionist blackmailer who's exaggerating her damages so she can squeeze the most amount of money out of Destiny possible, all that's really accomplishing is driving down the amount of money he will eventually have to owe her in the end. Which, even if we do assume he's able to drive that below $150K, he still is going to have to pay her the $150K in liquidated damages. If you haven't seen it yet, I say go watch my video covering his response because I watched the entire thing and break it down piece by piece and really point out all the flaws that I see with it. However, since posting my videos on this case, I've gotten comments from 2 different people, so shout out to you 2, that have raised the question over whether or not this law was actually effective at the date that Destiny sent these videos. And that's a very important question because if this law was not in effect, then Destiny can't be held liable because the law didn't exist yet. And under the doctrine of retroactivity, laws are not considered to be retroactively applicable. In other words, you can't pass a law to criminalize someone's past behavior. For someone to commit a violation of a law, very simply, that law has to actually be in effect at the time of the violation. So with that in mind, we have to understand when exactly 15 U.S.C. 6851 went into effect. And to do that, let's dive into the timeline. First step here, as I said earlier, Joe Biden signs the Violence Against Women Reauthorization Act into law on March 15, 2022. And as far as laws go, they are effective as soon as they are signed, which tells us that this provision here was in fact applicable as of March 15, 2022. Which then takes us to April 2022, when Destiny starts to message Rose through Discord, and at some point through his messages with her, he ends up sending the videos of Pxie to Rose. So as of now, it seems pretty simple, right? The law goes into effect in March, and Destiny begins talking in April. So at the very earliest, if we assume that on the first day Destiny was talking to Rose, he sent her these videos, that would still put his offense at least a month after this law went into effect, which would make him liable, right? However, let's take a look at these statutory notes, and specifically the section that talks about effective date of the law. As we can see here in section A, it says that in general, except as provided in subsection B, this act and the amendments made by this act shall not take effect until October 1st of the fiscal year beginning after the date of the enactment of this act, which is March 15th, 2022. So right, what this law is saying is that in general, the provisions of this act will not be in effect until October 1st of the following fiscal year, which, considering the fiscal year begins on October 1st, the date we're talking about here would be October 1st, 2022. Now, it does open by saying except as provided in subsection B, but if you read subsection B, it really only refers to some changes of definitions within this law that will affect other parts of the law, and so that's really not relevant for our discussion today. Which would mean that under this statutory note, the effective date of 15 U.S.C. 6851 is October 1st, 2022. And this delay in the enforcement date actually does make sense as far as new legislation goes. It's quite common that when new laws are passed that change the legal landscape, they don't go into effect immediately because we want to give people time to adjust and prepare for the changes coming down the pike so that when it does go into effect, it's not this huge seismic shift of the legal landscape. It's more so just a change that is clearly communicated and you just have to adopt. So with that in mind, you should start to see where this loophole is potentially happening. Because if this law really did not go into effect until October 1st, 2022, and it comes out that Destiny sent these videos of Pxie to Rose before October 1st, then yeah, this federal law is not applicable. And right, if you couple that with my assessment from my other videos talking about the Florida state law, which does require an element of intent to cause emotional distress, which I don't think is present here because based on my reading of the facts of this case, I don't really buy into Pxie's allegation that Destiny was sharing these videos of her as a way of causing her distress. Honestly, I fully buy Destiny's explanation that he just was sharing these videos to show himself off, and it just so happened that Pxie was in the videos. Of course, that's something that's going to get litigated, but just from my reading of it, I think it's going to be a hard sell to prove that Destiny intended to cause emotional distress, which if Pxie's not able to prove that, that would negate the application of the Florida law as well as the Florida tort law on intentional infliction of emotional distress. Because when it's an IIED claim, if you can't prove the first I in IIED, meaning intent, then you just can't prove the claim. So then that only leaves us with count 4, which is invasion of privacy. And while I'm not a Florida personal injury lawyer, based on a quick search of Florida personal injury lawyers, one in South Florida described invasion of privacy as occurring when confidential information about an individual is disseminated without their permission in a way that a reasonable person would find objectionable. So yeah, I'll let the Florida lawyers dig through that body of case law and hash out that claim, because this video I really just want to focus on the federal law. Because yeah, as of now, based on this loophole, it's looking like the federal law just simply doesn't apply. Which to me does beg the question as to why Destiny didn't say this in his 52-minute response video. Because he did make a point about the Florida law to say that the Florida law requires an intent to cause emotional distress and therefore it doesn't apply to him. It'd be a pretty good argument, if this is true, to say this law that I'm alleged to have violated didn't happen until October 1st, and I sent the videos before October 1st. At least allegedly sent, because you know that's how it works. But yeah, the fact he didn't say that or bring this point up does give me some hesitation as to maybe there's a piece of information that I'm missing that makes the federal law applicable. But without that supposed missing piece of information, my assessment as of now is that neither the Florida law or the federal law apply to this case. Now granted, this does not mean Destiny's off the hook automatically. Of course, as I said earlier, there's still the invasion of privacy claim, so we'll have to see how that gets litigated. But more importantly, the outcome of this case is going to hinge heavily on the litigation process, because as of now, a complaint's been filed. I still have not seen Destiny file his answer. Maybe it has been, I just haven't seen it yet. But since the litigation process has started, we've now entered the discovery phase of litigation. And what that means is that the parties now have subpoena power to subpoena records and evidence from the other side to then look for evidence to use in their own case. And Pxie's lawyers are undoubtedly going to try to subpoena all of Destiny's sexting conversations because they're going to want to see who Destiny sent Pxie's videos to, and more importantly, they're going to want to see when he sent those videos. And right, through this discovery process, there's two things I can see happening that will put Destiny right back under the gun and make this federal law snap back into place. First, it could be proven that he sent Pxie's videos to Rose after October 1st, 2022. All we know as of now is that he began talking with her in April, but so far I haven't been able to see an exact date of when he allegedly sent the videos to Rose. If Pxie's lawyers are able to find out through discovery that it was after October 1st, 2022, then right, the federal law snaps back into place, is fully applicable, and Destiny is going to be on the hook for at least $150K. So that's the first thing that could happen. The other thing that could happen is that Pxie's lawyers could find evidence that Destiny sent Pxie's videos to other people besides Rose and did so after October 1st, 2022. Because right, even though the complaint alleges that he sent them to Rose, which from what we can see is true, the complaint can be amended to include other people that it was sent to, which is particularly important if it happened after October 1st. And so right, assuming Pxie's lawyers are able to find evidence of that and can squarely, definitively say it happened after October 1st, then once again, Destiny will be right back under the gun, on the hook for at least $150K. But this whole discovery process is going to take place behind closed doors, so we're really not going to know anything for a while. But until we find out something further, it looks like Destiny could be off the legal hook entirely. Now, whether he's off the moral hook, that's another question, but I'll let y'all figure that out on your own. But yeah, that's the potential loophole that could save Destiny. Which brings me to the last part of my videos on the Destiny case, and that is the cooked meter and how cooked I think Destiny really is. And so far, my score on the cooked meter has fluctuated between an 8 out of 10 and a 9 out of 10. But right now, I'm gonna cheat and I'm gonna split my cooked meter into 2 separate cooked meters. I know, crazy. And there's 2 separate ones because one is gonna be my meter if the federal law is applicable, and the other is gonna be if it's not applicable. And so yeah, if it comes out that the federal law is applicable, I'm still having my cooked score at an 8 out of 10 because I still think it's quite obvious, quite evident that Destiny did violate this federal law and is going to be on the hook for at least $150,000. Now as for my other cooked meter, that's going to be the one that applies if the federal law is found to be inapplicable. And on that meter, I'm giving it a 2 out of 10. And yeah, it's a drastic drop off because, put it simply, if there's no federal law and no state law that governs your misconduct, then it's going to be really hard to prove a case. And the only reason I'm putting it at a 2 out of 10 and not a 0 out of 10 is because of the pending invasion of privacy claim. Based on that Florida lawyer's reading of it, sounds like it definitely could be applicable, because I think we can all agree it would be quite objectionable if any of our nudes were shared without our consent. But there very well could be an intent element to that could fall under the same analysis as the intentional infliction of emotional distress and the Florida sexual cyber harassment statute. But either way, like I said, I'm leaving the Florida lawyers to litigate that one out, and I'm putting my alternative cooked meter at a 2 out of 10. But yeah, that's all I've got for today's video. If you learned something new, then drop a like down below, let me know. And want to get all the juicy updates from the Destiny vs. Pxie case, then be sure to subscribe to come back for more. And most importantly, of course, I want to see y'all down in the comment section. Let me know what you think. Does this loophole matter? Is it real? Is it applicable? Am I making stuff up? I want to hear it all, because that's my favorite thing to do on this channel, is to be down in the comments chatting it up with y'all. And who knows, since the idea for this video started out as a question posed by not 1 but 2 commenters, maybe your comment's going to be the basis for my next video. But either way, I look forward to chatting up with y'all down there, and I will see you all on the next one.